No citizen can be deprived of her liberty unless authorized by a due process of law. Now, arrest or detention, therefore, leads to curtailment of liberty, and the concept of bail is linked to this very ideal of liberty. The law presumes each individual to be innocent until proven guilty. It is on the predication of liberty as a fundamental right does bail become the rule and jail the exception. Despite the Supreme Court and various high courts reiterating the principle of bail being the rule and jail being the exception, the reality on ground seems starkly different. Liberty is at the heart of democracy. Every law-abiding individual is free to live his or her life as he or she seems fit and indulge in all legally permissible pleasures. In fact, freedom of movement itself is a fundamental right. No citizen can be deprived of her liberty unless authorized by a due process of law, that is, by a law which itself is fair, just and reasonable. Now, arrest or detention, therefore, leads to curtailment of liberty, and the concept of bail is linked to this very ideal of liberty. It is on the predication of liberty as a fundamental right does bail become the rule and jail the exception. It is open to debate how much of this is actually followed in reality. The issue regarding bail has been discussed widely in public fora and in media, often due to the high-profile individuals being arrested and on many occasions denied bail for prolonged periods. The issue, however, at most times is superficially discussed and deserves a much more granular discussions and debate. We must segregate the hype around certain high-profile cases from the overall discussion if one were to try and understand the concept of bail in its jurisprudential merits. First, let's briefly understand why in law was the concept of bail devised. Whenever a person accused of an offense is arrested, the person must be produced in a court of law before, let's say, a judicial magistrate. This is the first check devised by the criminal justice system to ensure that the police has done its job properly and no innocent person is deprived of his or her liberty illegally. When an accused is presented before court, the person gets the opportunity to point to any wrongs committed against him whilst in police custody. To avoid and at times to identify police excesses, a medical checkup has become a mandatory measure in law for all persons who are arrested or detained. The opportunity to seek bail is an extremely important right conferred upon an accused whilst the alleged offense is being investigated. The concept of bail is also based on the fundamental premise that the law presumes each individual to be innocent until proven guilty. There are various factors that a court would consider before deciding on whether bail should or should not be granted. The most important is the nature or kind of offense for which an accused has been arrested. That takes us to the very important distinction that law has ascribed, that is, whether an offense is bailable or non-bailable. The procedure for securing a bail differs depending upon the type of the offense. The court will decide on granting of bail depending upon the gravity of the offense, whether it is a minor offense, for example, a petty quarrel or a theft, or is it more aggravated, illustratively, a bank robbery or a sexual assault or even murder. Of course, the procedure would differ too. For bailable offenses, bails ought to be compulsorily granted and can be secured at the police station itself without the need to approach a court of law. For more serious offenses, which are categorized as non-bailable, bail is granted by a court. Now, what does a court consider while granting bail or in a matter while refusing bail? The court has a discretion to grant bail in case a person is arrested on an accusation of a non-bailable offense. In order to provide guidelines for the exercise of such discretion, the Supreme Court has reiterated the principle that bail is the rule and jail is an exception. The rule finds its constitutional manifestation in the fundamental right to life and liberty enshrined in Article 21 of the Constitution of India, and any deprivation of that right under Article 21 can occur only by a process established by law, that is, by a law which is fair, just and reasonable. Multiple constitution benches of the Supreme Court in landmark cases have repeatedly reiterated that the courts should lean against the imposition of unnecessary restraints. Various judgments of multiple high courts in the country have repeatedly stressed upon various factors that should be considered liberally when courts exercise discretion to grant bail. The enormity of the offense alleged, the nature of the accusations, the severity of the punishment which a conviction will entail, and the nature of evidence available in support of the accusation. The dangers of the application applicant absconding if released on bail, the danger of witnesses being threatened or even evidence being tampered with, the protraction of the trial itself, the opportunity of the applicant to prepare his defense, access his counsel, etc. And finally, the health, age and sex of the person accused of an offense. These are all crucial factors that a court will consider while granting bail. A complex but judicious analysis ought to be undertaken by courts of law. But there are gaps in practice. Despite the Supreme Court and various high courts reiterating the principle of bail being the rule and jail being the exception, the reality on ground seems starkly different. The overcrowded Indian prisons point to the glaring lapse that plague the criminal justice system. Despite such robust jurisprudence on grant of bail, jails in India are flooded with under-trial prisoners. Statistics indicate that more than 2/3 of the inmates of Indian prisons constitute under-trial prisoners, and amongst under-trials, majority might not even be required to be arrested despite a registration of a cognizable offence, most being charged with offences punishable with imprisonment for 7 years and less. This, in a way, exhibits the mindset on the part of the investigating agencies, the mindset that natives will dodge the law, such a mindset being a vestige of colonial rule, ignoring the fact that arrest is draconian measure resulting in curtailment of liberty and thus ought to be used sparingly. The Law Commission of India, in its 154th report, reviewed the law on arrests and supported the conclusion reached in the 3rd report of the National Police Commission that a major portion of the arrests were connected with very minor prosecutions and cannot therefore be regarded as necessary at all from the point of view of crime prevention. The Law Commission also noted that over 60% of the arrests were unnecessary, and such arrests accounted for more than 40% of the entire prison expenditure in our country. As we speak, there are about 2,20,000 bail applications pending before the trial courts, although the disposal rate of bail applications in trial courts is high and is at approximately 2 million each year. In case of high courts, about 1,13,000 bail matters are pending, although the disposal rate for bail applications in high court is approximately about 3 lakhs each year. It is appalling to see that around 21% of the bail applications pending before the trial courts and about 36% of the bail matters pending before the high courts are pending for more than a year, which demonstrates the backlog and the overcrowded judiciary, resulting in the unintended consequence of deprivation of an individual's personal liberty. Recognizing the issue, the Supreme Court in a recent case suggested that the Parliament consider a separate legislation governing grant of bails. The United Kingdom, for example, has a special legislation for bails. Bail jurisprudence and the legal framework surrounding its implementation require immediate reform for a variety of reasons. The foremost is the huge pendency of bail applications and the fate of under-trials in overcrowded prisons in our country. The Supreme Court has expressed its concerns on this issue many times. The overcrowding also hinders prison reforms. The biggest irony is that jails are crowded with individuals accused of petty crimes who ought not to be there in the first place, whilst the ones who deserve detention might be roaming free. Data depicts that most of the under-trial prisoners, apart to being accused of minor offences, also hail from socio-economically marginalized groups at a time when the government is taking active measures to shed the colonial remnants in the justice delivery system by initiating criminal law reform and promulgating new legislation. Perhaps the long pending prison reforms should also receive requisite attention.